Matter of Night Clue versus City of Rochester, and for it, we are delighted to be joined by our colleague from the First Department, Appellate Division, Justice Anil Singh. Counsel?
Good afternoon, Your Honors. May it please the Court. Patrick Beath, Corporation Counsel for the City of Rochester. I would ask to reserve 3 minutes for rebuttal.
Yes.
To be clear, the City of Rochester has released, continues to release, through FOIL and affirmatively, law enforcement disciplinary records. And when I say we release law enforcement disciplinary records, I'm talking about records that involve the commencement of an investigation and a hearing or the imposition of discipline, where there's an actual disciplinary finding or a hearing, regardless of outcome, over charges of misconduct. The issue in this case, though, is not about those disciplinary records. The issue here is about unsubstantiated records and whether those are subject to release.
Would you agree that under FOIL, that FOIL requires disclosure of quote-unquote all records, and that would necessarily include law enforcement disciplinary records, subject, of course, to statutory redaction?
There's a presumption of access to government records under the FOIL law of all sorts, be they disciplinary records, be they records of allegations of misconduct against law enforcement or other public employees, or be they financial records of a city. However, there are a number of exemptions to those disclosure presumptions, one of which is where disclosure would constitute an unwarranted invasion of the individual personal privacy of the individual at stake.
And haven't we said that we find blanket exemptions inimical to our holdings, where we say, look at each record and see if it's responsive, as opposed to this blanket exemption that I think you're advocating for?
In other contexts, yes, Your Honor, that is what the courts have said.
So it doesn't apply here? Is that what you're...
I think where we're talking, whether it be law enforcement misconduct, allegations of misconduct, or general public employee records, we have a unique type of record, and I think a blanket withholding does make sense here.
Well, except for this unique type of record, the legislature simultaneously adopted a redaction scheme, right?
Part of the argument we're making, however, is that unsubstantiated records of allegations of misconduct are not law enforcement disciplinary records as defined under the FOIL law.
Well, if they're not, then you have no basis to redact anything from them.
We do, as we would any other record.
Wait a minute. The law in question defines a law enforcement record as the commencement of any investigation in any subsequent hearing or disciplinary action.
And I think the key there is the conjunctive use of and the disjunctive use of or.
But so if you're using this conjunctively, it restricts the category of things that you can make redactions from. The rest are just records that you have to produce. I think you would want to read it disjunctively to make your ability to redact greater. I think you've got this backwards.
No, I think in law enforcement disciplinary records context, the ability to redact is slimmer than other records of general application. We always have the ability to redact to protect against intrusions into personal privacy, which is what we've done for years in the context of non-law enforcement public employee records. The Committee on Open Government in those contexts has said for non-law enforcement public employee records, you may withhold those where there's unsubstantiated allegations of misconduct, because to do otherwise would be an invasion of personal privacy, an unwarranted invasion of personal privacy. Our argument is that the changes to the FOIL law only concern records where there's sustained charges and a hearing or discipline. Those then, for instance, you're not allowed to redact the subject officer's name. In the context of unsubstantiated allegations, even for non-law enforcement public employees, we've always been able to withhold those records under Committee of Open Government opinions. So at a minimum, we should be able to
How much
make
rooted in the
redactions.
privacy interest of the subjects, or is it something other than that? Is there some statutory source for that, right?
It's the privacy. The Committee on Open Government opinions for the past number of decades have been focused on the privacy interests.
How much weight should be given to those opinions?
I think you should give considerable weight to those opinions for a number of reasons. One, because this is the business and has been the business of the Committee on Open Government. These are the issues that they deal with on a regular basis. Two, when the FOIL revisions were put in place and when the disclosure of the documents at issue here were tied to a disciplinary proceeding, that was all done in the context of the legislature knowing that history of Committee on Open Government decisions, which regularly opined that where allegations were unsubstantiated and did not lead to discipline in a non-law enforcement public employee context, they could be withheld. If the legislature wanted to deviate from that and make law enforcement records that were not substantiated more accessible than standard non-law enforcement public employee records had been under Committee on Open Government opinions, they should have said that in the FOIL revision.
But counsel, assuming all of that's true, if the source of the right is the interest of privacy, and the statute is now configured, or the statutes, the FOIL law and the public officers law, or wherever it comes from, require a particularized showing with respect to the privacy to be protected, I don't understand how any of that gets you to a blanket exemption.
Because every time we're dealing with unsubstantiated allegations of misconduct, we're dealing with potentially defamatory allegations that after an investigation haven't been able to have been proved. So we see analogs in other contexts.
So you show that, you demonstrate that to a court. I mean, that could be true. There could be a lot of reasons why you wouldn't want to disclose it, that the damage to be done is far outweighs any interest in looking at it. But you can't claim that for, my reading of the statute is you can't claim that categorically for the entire body of unsubstantiated disciplinary records. So why is that wrong? How am I misreading the statute?
Because I think of the, well, I think the statute needs to be read in the context of years of Committee on Open Government opinions, which said that you may withhold those sorts of records. And I think the reason for
Are
that
the more current decisions from the Committee on Open Government, are they suggesting a different view at this point?
I think they're following the lead of various courts that have decided the matter since the revisions in 2020 to the FOIL law. But this court obviously has the authority to say otherwise and opt for the position of the Committee on Open Government that was maintained for many years.
But your position is that we should follow what the Committee on Open Government is saying, and as if they've now changed their view of it, isn't that something we would look at?
I think the Committee on Open Government was right at the time that the FOIL revisions were put in place. And that was that the release of unsubstantiated
Does not
claims.
context matter? The times change and they change? Does that not matter?
I think we're looking at the language of the revisions of the FOIL law revisions.
Well,
and
if
so-
you look at the language and when it gives the definition, where does it say unsubstantiated is not to be released?
Where does it say unsubstantiated is to be released? And that's part of the problem. The part of the problem is that when it defines law enforcement disciplinary records,
So they get to be excluded by silence?
In light of
Is that your suggestion here?
my suggestion is that in light of the long history of the Committee on Open Government, indicating that withholding unsubstantiated records because they would work an unwarranted invasion of personal privacy, that yes, the legislature had to do more than just be silent about unsubstantiated records.
Do you still have the protection of redactions?
Redactions are protective to a certain extent, but are not as protective as withholding altogether. Redactions run a risk that if redactions are missed, then private information goes out into the public. Redaction presents a challenge where people can take a redacted report that may
And
de-identify the subject officers.
Does a blanket prohibition create a situation where people, although unsubstantiated does not necessarily mean innocent, and the decision-making of those who may transfer them to a different department, or the idea of FOIL is public disclosure of information, correct? Isn't it a free-flowing idea as opposed to a holding back unless specifically indicated otherwise?
That's correct. And the idea behind holding back this type of record is that this type of record is always an unwarranted invasion of personal privacy.
Always.
Because the allegations after investigation are not sustained. And so it's...
But how does that analysis comport with the statute? Because certainly the statute doesn't say that. There's nothing in the statute about unsubstantiated records. The statute, in fact, defines law enforcement disciplinary records as records created in the furtherance of a law enforcement disciplinary proceeding. So it's all those records, names, complaints, allegations, correct?
Unsubstantiated records would never be a record created in furtherance of a disciplinary proceeding because the proceeding only occurs once charges are imposed. That's why the definition, if the legislature wanted to include unsubstantiated records, they could have defined law enforcement disciplinary records as all records resulting from the commencement of an investigation.
But again, that
period.
definition is for the purpose of determining what can be redacted. It's not a carve-out of the general requirement that all records be produced.
I agree with that, and that's why I rely on the long-standing precedent of the Committee on Open Government, which is the one that is very
Although
much.
most of that longstanding precedent is before the law was changed.
But the changes to the law did nothing to unsubstantiated records.
That seems, you were kind of spinning around in circles.
If anything, what the law did was make clear that law enforcement records should be treated just the same as the personnel records of any other public
It
employer.
clearly did the opposite because it created specific exemptions for law enforcement records and defined them. It clearly perceived a difference between the two.
It rectified the fact that law enforcement used to get special treatment under Civil Rights Law 50A. But ultimately, what it did
Well, it still gets special treatment because there's provisions for law enforcement records that just apply to law enforcement records. They're not treated the same as other records.
they make,
On the face of the statute, they're not.
arguably, they are consistent with prior Committee on Open Government rulings concerning general employee records because they tie disclosure to a disciplinary proceeding, which is consistent with the Committee on Open Government opining.
But you're essentially saying they didn't need to put in the whole business about police disciplinary proceedings because that would have been the law anyway. It's all superfluous.
I think they could have alternatively just simply said, records of law enforcement entities shall be treated the same as general municipal employees. And it
Counsel,
would
can
have
I just
achieved
ask
the
you
same
very
end result.
quickly?
Yes.
With respect to this distinction between investigations and proceedings, drawing that line, 86.6 says that disciplinary records are any records created as you pointed out, created in the furtherance of a law enforcement disciplinary proceeding.
Right.
Then goes on to say, including, but not limited to, complaints, allegations, and charges made against. To me, those three things, complaints, allegations, charges, or maybe the first two at the very least, are things that you would expect to happen before there is a proceeding. So could we not read the language of the statute as being much broader than you're representing it to be here?
So I think
And
the
if I may add to that, before you answer that, 86.7 defines enforcement disciplinary proceeding as the commencement of any investigation. So why is not an allegation that has to be considered, reviewed, part of the commencement of any investigation?
So if we look at the definition 86.7 of a law enforcement disciplinary proceeding in its totality, it's the commencement of any investigation and any subsequent hearing or discipline. The argument that we're making is that that's a two-part test. The
And if
commencement of the
we don't
investigation
agree with you,
and
do
the
you
hearing.
lose? Does it turn on this?
I'm sorry?
Does it turn on this? Does your argument turn on this?
The argument turns on this and the past treatment of disciplinary records in the context of non-law enforcement public servants.
Thank you.
To your question, law enforcement disciplinary records. If the 86.6 definition had said law enforcement disciplinary records consist of the following and gave that list, then I would agree with your argument, but that's not what it says. It says law enforcement disciplinary records are those created in furtherance of a disciplinary proceeding and include the following. The disciplinary proceeding is the gateway.
So the triggering event is the proceeding as you define proceeding.
It's the proceeding as proceeding is defined in the civil service law and the FOIL law. In the civil service law, section 75, a proceeding commences with charges. There's an 18-month statute of limitations to bring a disciplinary proceeding. That 18 months is
Well, why
measured
should
from
we
the
look to
service
that
of
when the
charges.
FOIL law describes it, when 86.7 describes it for purposes of the
So
public
86.7
officers law? Why are we looking anywhere else?
And that is consistent, if you read the and the or, as they should be read, conjunctively and disjunctively, that is consistent with disciplinary proceeding under the civil service law, because it is the commencement of an investigation and a subsequent hearing or discipline. Civil service law, the proceeding is the service of charges, which is a sustained allegation, and then a hearing or discipline. So those two things are in my opinion, the legislature was very careful in crafting
Why isn't
this
it the
language.
commencement of any investigation as well as a subsequent hearing or disciplinary action conducted by the agency?
I think if it had been written, the commencement of any disciplinary proceeding and any hearing and any discipline, then that would be a wash. Same thing if it were all disjunctive, but it's not. And so.
So you mean
by
it's the use of the "or" between hearing and disciplinary, hearing or disciplinary, excuse me?
Combination of the use of "and" after commencement and "or" between disciplinary and hearing, yes.
Thank you.
Thank you.
Thank you, and thank you, and may it please the court. Bobby Hodgson from the New York Civil Liberties Union Foundation.
How do you respond to your adversaries, or this precise point that he's making?
I think this is that what they propose is not a plausible or even a possible interpretation of the words "and any subsequent." I think, as Judge Rivera points out, the definition is expansive and inclusive. And I could give an example. If my employer were to say, you have to submit receipts for any business meal, and we're defining a business meal to include the first course you order and any subsequent dessert or drinks. If I don't have dessert or drinks, I've still had a business meal, and I still have to submit the receipt. The words "and any subsequent," they're asking you to read those to mean only if there is a subsequent, and that's simply not what they mean.
My problem, which I guess I've asked about, is that I read those words as coming to define the scope of things that can be redacted pursuant to the provisions allowing for redaction, not a definition of what, in the first instance, what FOIL applies to.
Well-
And for that reason, I think they should want them to be read expansively because it allows them in more types of records to redact things. And if they read this narrowly, to require that there be a hearing, they may be required to produce things that they can't redact.
Well, I think the narrow reading is conflicting with the rest of the language of the statute for many reasons, and that's one of them. But I would submit that it does more, so by defining something as a law enforcement disciplinary record, that includes affirmatively allegations, complaints, the name of the officer complained of or charged. And then there is a specific set of mandatory and permissive redactions that, as you point out, the legislature has created. They considered what should mandatorily be redacted from all those records. It's information like officers' addresses, phone numbers, medical histories. And then there's a permissive set of redactions for things called technical infractions, which is a very limited term of art.
Is that an exclusive or non-exclusive group of exceptions with respect?
It's non-exclusive to the extent that civil rights laws, that the public officers laws general invasion of privacy exemption.
So then next what? If it's not within these exceptions, what do the courts require at that point? Don't they require a balancing of the privacy interests versus the right to know?
They do, but we submit that the fact that the legislature created such a detailed scheme and considered what should mandatorily be redacted from these records, what should permissively be redacted, and that they did not include unsubstantiated complaints. They did not include the names of officers complained of or charged. You cannot read the statute consistent to say then the general invasion of privacy exemption can somehow apply to all that material. And we would say that even more than that, it is affirmatively included in the definition, the name of the officer complained of or charged. They cannot then turn around and interpret the general provision to say, well, the name of every officer complained of is material that is an invasion of privacy.
Could they make, under sort of general FOIL provisions, a specific application? In this particular case, this would work some undue harm.
Absolutely. We would submit that those invocations of the privacy exemption would be subject to the same test that there has always been, which is they have to come up with a particularized and specific justification for it. We would also submit, though, that it is a narrow universe of records, particularly when you're talking about the items affirmatively named in the definition of a law enforcement disciplinary record, allegations, complaints, the name of the officer complained of or charged. It would be.
What about the argument that other government employees' unsubstantiated records are exempted, but not police officers?
I think that's not true for a few reasons, and I'm glad for the opportunity to clarify. It has never been the case that every public employee has a blanket exemption for unsubstantiated complaints. We cite to the Thomas versus New York City Department of Education case from 2013 in the First Department, where the First Department said exactly that. And that wasn't to do with police records, that was to do with educators. It said there is no blanket exemption for quote-unquote unsubstantiated complaints, because of course you are always balancing the public's interest in a particular record with the privacy implications of it. We would also point out that those are decisions from a pre-2020 world. Post-2020, the FOIL has been amended. It now says affirmatively, allegations, complaints, the name of the officer complained of or charged is an affirmative part of the records that must presumptively be produced, and it's not listed anywhere in the mandatory or permissive redactions. And the Committee on Open Government in 2022 issued a very specific and very strongly worded rejection of Rochester's proposed interpretation here. It said that it would undermine the public trust in police accountability to create this broad secrecy. It would go against the legislative intent and the plain language of the statute to create an exemption for materials that are related to unsubstantiated complaints. And I
Does
think
that operate as a repudiation of their prior position on the disclosability of these documents?
Well, I would start by saying that their prior position is not that categorically all unsubstantiated complaints are always subject. They've always said they may constitute an unwarranted invasion of
And in
privacy.
any event, with respect to their prior positions, was there any appellate case law that supported those positions? I know they went to the trial court. There was a trial court order that purportedly supported that position, correct?
No, Your Honor, and the answer is no, there was not appellate support for that position. In fact, the Thomas case I mentioned from the First Department rejected it explicitly. There were other cases where individual records of educators, for example, were found to be redactable because they were related to an unsubstantiated complaint. That's the LaRocca case mentioned in the briefing. But in that context, they pointed specifically to the fact that there was a standalone separate statute, Education Law 3020A, that rendered educators' records confidential in that context. Of course, the analog to that is Civil Rights Law Section 50A, which no longer exists for police. I do want to speak a bit about the legislative intent here, because I think it could not be clearer that legislators who were voting both for and against this law knew exactly what it would do, and that it would reveal and force agencies to produce records related to unsubstantiated complaints. We point in our briefing to statements by legislators who are saying, I'm voting for this because it will reveal how police accountability works and why it is that, for example, 4,000 complaints of racial profiling in New York City resulted in 0 substantiations. They talked about how
Are you pointing
that...
to legislative intent because you think it's possible that there may be some ambiguity in the
Absolutely
statute?
not. I'm saying that it is very clear. They looked and they said, look, this is the kind of thing that will address what the public is calling for, will build trust between departments and the public by saying, let's show our work. Let's take away this veil of secrecy so you can see what happens when someone makes a complaint of police misconduct. And you have departments since 2020 that have fully embraced that. Hundreds of thousands of these records have been made public since 2020 with only good results, a better understanding of what police accountability looks like in people's communities. Every appellate court to have considered this precise question has come out the same way. You have places like New York City, but also like Utica, saying we're going to affirmatively put up all of our disciplinary records alongside things like commendations and honors, because that's how we show this is what accountability looks like in our community. This is transparency that should be good for everyone, and legislators recognize that. They did also say, though, that in the legislative history, the repeal of Section 50A and the amendment of FOIL would allow, for example, Ramarley Graham's family, someone who had died prior to 2020, to finally see the police records that had been kept secret since his death. Eric Garner's family, who died prior to 2020, they said that this repeal would allow his family to finally see those records. They talk in the sponsor's memo about how the initial purpose of Section 50A was very narrow and was to address a specific issue, but that over the course of time, it had been expanded in the courts to be so sweeping as to create this veil of secrecy, and that this enactment was intended to correct that. And
You argue in your briefing that the names of police officers should always be provided unredacted.
Not always, but the presumption has to be that those names should be provided, and there has to be clarity on that, because we've seen...
Couldn't there be a balancing on that, where courts or agencies would, in the first instance, decide whether or not that should be released because there may be a privacy interest or reason why it shouldn't be?
I think that there are examples where that may be the case, but I think it's really important that there be clarity, that there can't be a categorical withholding of all officer names.
So it
or
comes
a
up in the
presumption that there would
context-
be anonymity.
You would raise it in a particularized objection to that record.
That particular record. And obviously, many FOIL requests are such that there's a request for, hundreds of records, and you have agencies saying, well, we're going to categorically redact every officer's name, or if we can't anonymize these records, we're not going to turn them over. And that is clearly inappropriate because the statutory text includes affirmatively the name of the officer complained of or charged. It would be a rare case, but one that may exist, where an agency could say, oh, this particular officer changed their name legally in the past because of a particularly personal reason, and it's not relevant to the public, and maybe we can redact it there. But there has to be clarity on this issue because, 4.5 years after the repeal of 50A, many agencies around the state, unfortunately, continue to categorically withhold things like officer names on a broad blanket basis, or continue to insist that they'll only turn over records if they're anonymized. And that's not consistent with the text of FOIL or the legislator's intent when they passed it. If your honors don't have any further questions, I think I would go back to the final thing I said, which is that this case presents an opportunity for the court to give much-needed guidance, not just in this case, but to agencies around the state who are engaging in responding to these FOIL requests at a time when categorical invocations of the privacy exemption or other exemptions to blanket withhold officer names or allegations or complaints are something that's happening repeatedly. So to provide the specific guidance to agencies to say, it is not just a universal blanket, unreasoned denial that is inappropriate, but instead, when materials are affirmatively included in the statute, the name of the officer complained of or charged, the allegations, the complaints, those are materials that presumptively have to be turned over. Thank you, Your Honors.
Thank you.
Just briefly, Your Honor, to the point of redaction of, particularly in the case of unsubstantiated records, I think the revisions to the FOIL law creates specific things that may or may not be redacted as far as law enforcement disciplinary records go. Again, we would argue that unsubstantiated complaint records fall outside of that definition, and even if this court were to find that those are subject to disclosure, subject to redaction, we would want to make sure we have the ability to still redact individual names and facts in the interest of personal privacy.
But isn't that inconsistent with the statute? The statute says specifically, complaints, allegations, charges, names of employees complained of or charged. So isn't your friend's point strong that there needs to be essentially a balancing? The names may not, under certain circumstances, be turned over for whatever reasons because of the balancing. Isn't that how it should be handled?
And this goes back to the argument that I made previously, that unsubstantiated records, by definition, cannot be disciplinary records. They cannot result in discipline. They can never result in charges. And so they should be treated differently. So even if this court finds that a blanket withholding, as we would argue the Committee on Open Government used to support, is not appropriate going forward, we would still want to make sure we have the latitude to make redactions as appropriate to protect personal
So
privacy,
is your point that-
particularly where allegations are not sustained.
Are you trying to make the point that a disciplinary proceeding is a term of art, and we're to take your word for what it means and ignore the context and the other examples in the statute? I mean, you're basically telling us that's not what a disciplinary proceeding is.
I'm saying that what a disciplinary proceeding is, if we read the definition as conjunctive, having two pieces, that it's consistent with the definition of a disciplinary proceeding in the civil service law, which is a close analog because that's always been applied to civilian public employees. So I'm not asking you to ignore the language of the current statute. I'm suggesting that it should be read in a
But you're
very
suggesting
specific way.
that names should always be withheld.
Not where we have sustained discipline.
Unsubstantiated complaint names, correct me if I'm wrong, you just asked that they be subject to categorical redaction, if we find that they're nonetheless disclosable, right?
No, that the municipality have the discretion to be able to redact those.
Meaning that we should leave it to the municipality to decide when to redact and when not to redact?
For unsubstantiated records.
And
Yes.
would it be cynical to say that then they're always going to be redacted?
I don't know whether or not it would be cynical. Time would tell, and those would still be able to be subject to challenge, right? They could only be redacted if the municipality could show that it would work an unwarranted invasion of personal privacy. But
So in other
certainly-
words, the balancing,
Correct.
that the balancing favors the police officer in that instance with respect to that unsubstantiated claim, correct?
It would
Not
more-
all claims.
Yes, it would more often favor the police officer because of the nature of the unsubstantiated allegations, yes. Thank you all.
Thank you.